Welcome to the Plant Grow REIT podcast.
Welcome back to the Plant Grow REIT podcast. I'm Andrea, and this is the second episode of our What Your Lawyer Wants You to Know series. And today we'll be tackling estate planning. And I'm joined by the fabulous lawyer at our office that looks after estate planning for our clients, Roberta Tabakova. And did I get it right?
You did.
There you
Fantastic.
go. We were talking just before we went on air about how I pronounce Roberta's surname so that I get it right, because sometimes in the grand scheme of things I don't. And thankfully we've got a great editing team in Kane to make sure that it all sounds good. But we've got it right today. Roberta works closely with lots of our clients across the board, managing estate planning matters, talking about really complicated things like wills and trusts and binding death benefit nominations and all sorts of things that in normal life we tend not to think about, but we do have to think about them. So we've got Roberta in today to chat with us all things wills and estate planning so that everyone has a really good idea of the basics of what you've got to do. If you want any more than the basics, give us a call and make a time to talk to Roberta in person, because it's the best way to do it. You can't, it's one of those things where you can't do your estate planning by writing stuff on the back of an envelope. Can you, Roberta?
No, you shouldn't. You should not be doing that. Some people do. You should not be doing that.
Yeah. And I think that's what we would like for everyone to come away with from this episode, is that it's something that needs to be a little bit planned. Like, you can't just think, oh, whatever, it'll all work itself out in the end, because you've probably seen situations where people have thought, oh, I've got this will that I just downloaded off the internet and put some things in. What happens when those things, what are the bad things? Let's start with the bad things. Let's do the horror things first.
I've got a lot of examples.
I can imagine.
First of all, thank you for having me. I'm very excited to be on this podcast today. I had a recent one where the will was done in a post office. So that's your classic horror story. There was no lawyer involved, no legal advice given. The first clause was straight away wrong. So you didn't even want to read the rest of it because the executor clause was invalid.
Oh, gosh.
So what they had done was, it wasn't invalid per se, but the lawyer appointed had no connection to the client. They didn't give any legal advice drafting it. They just put them in there by knowing the name of the solicitor, which is very wrong, because the solicitor has no knowledge of this will existing. It wasn't executed properly. One of the witnesses didn't sign one of the pages.
Oh, gosh.
And then there was most importantly, there was no alternative executors. So the executor that was appointed, the solicitor in question, had died because the will was very old. So again, no executor, and now we had to do it the hard way. So we actually had to assist the children, being the beneficiaries, going through letters of administration, which is a process where the will is invalid or some of the clauses are not appropriately drafted, and then you had to apply for, I guess, a different way of saying probate, where the executor is not known or has died and there's no alternatives. That's, again, more expensive and then more hoops to jump through, obviously. So it wasn't ideal. The beneficiary clause was also not drafted very properly, in a way where the daughter was getting more than the son, which wasn't the intention of the deceased by everything that we had discussed with the children. So again, we had to do a deed of family arrangement, which is both the son and daughter agreeing to an equal split, because they deep down knew their father would never try to draft a clause where it splits the assets in an uneven way. So it cost them a little bit more than he should have. And if the dad back in the day had obviously obtained proper legal advice and gone to a lawyer, I have faith that the clauses would have been drafted appropriately and this wouldn't have happened. So there we go, one horror story.
And almost everything that could have been wrong was wrong.
Yes.
I think it's interesting because, and you said this when we were talking, there is no register of wills. Like you can write a will and not tell anybody about it, and nobody literally knows that it exists. And I think that is a super funny thing. Like in my mind, it is just wild that we don't, even when you go to a lawyer, they don't have to register your will with anybody. They obviously keep a copy of it.
Yeah.
But there are situations where families will just say, oh, we didn't know our parent had a will, and therefore, oh, well, we're just going to do it our own way.
Yeah.
Which is wild when you think about, how the whole system works and, leaving assets to family members, and what do you do in those situations. So it's a strange situation to be in, that's for sure, that you would have you've got a will, even if it's bad, and nobody needs to know that it exists. And lawyers, you are obviously in a situation where you would be not necessarily legally obliged to be doing anything with a will. Like if you find out that somebody has passed away and you have a copy of their will, as a lawyer, is there a responsibility to say, hey, hang on a second, people, there's a will here and I've got a copy of it? Or does it's just up to the families?
That's a very good question. So really depends if it's a couple and the first of them dies. So the survivor usually has the right of survivorship for most of the assets. So we have noticed that sometimes we would have the wills of a couple. When the first one passes, then the second one gets the survivorship, right of survivorship for their main residence most of the time, and the bank accounts happen to be joined. And then the surviving spouse or the children don't really look for the will because then probate isn't necessary unless the first one to go ahead assets in their sole name. When the second person goes, though, that's when it becomes very important to communicate with the lawyer and do the probate application. Some families don't like discussing their wills and who holds their wills. I think that needs to change, and a lot more open conversations need to happen with your children. I've had a lot of my clients ask me, I've done this will, should I tell my children? Absolutely. You don't have to tell them what's in the will. Absolutely not. That's your private document and confidentiality applies. But your children should know where your will is stored. Because it's not the lawyer's responsibility to look for the children. Usually the wills are drafted in a way where the children's name and address are there, but sometimes the address is not even there. It's just the full name. So we're not investigators. We can't go down a rabbit hole to try find the next of kin. So it's important for the kids to be able to reach out to us, and we're always here to help.
It's certainly an interesting thing. Let's take it a couple of steps back as well, because estate planning isn't just about writing a will. It's about a whole range of things. And people sort of think, oh, but I've got nothing, I don't really have a lot of assets, or I've only got a family home and it's not really worth much and all of that. But it's not necessarily about, what assets you've got. And sure, you've got to write them down somewhere and say which of your children sometimes that you want to receive them. But it's for us when we have these conversations, and I'll always remember that when I sat down for the first time with Peter, who's our, director lawyer, and he said something to Shane and I when we sat down with him that was beyond just, what do you want your will to say? And it was, what do you want your legacy to be? Like what is it that you're trying to build, and how do you want it to look down the track? And he said to us, it's all right for you and Shane to sit in this room and have a conversation about what you want it to look like, but actually it's not going to be for the two of you, because essentially one of you dies, and as you said, Roberta, the survivorship happens, so there's no need. But what about the second time? And how does it involve the kids? And he was really firm on the kids should be in here at this table having this conversation. You don't need to talk about all the dollar values and all of that sort of stuff, but they've got to understand why you've done what you've done and how you've built it the way you've built it. Because sometimes, and most of the time, families aren't straightforward. There's all sorts of things that can go good or bad.
Yeah.
And sometimes in the situation where you've described before, where you were lucky that the children said, Dad would have wanted us to share this half and half, there are circumstances where Dad may not have wanted to share half and half, and the kids may not have had that sort of relationship. How important is it for you to be able to sit down with your family and say, I've actually decided that this person needs to get more than this person because this person has a range of things that they have had go on in their life that have meant that they need more support? And how, what do you do when you're building those conversations with people? Because they're probably sitting in front of you going, oh, can't we just sign some sort of like pro forma thing? Don't you just have this like simple thing that I can just sign, Roberta? Why do I have to have these conversations with you?
So those are actually very tough conversations because on the face of it, you think that each person who has multiple children will want them to benefit equally. However, there's a lot of cases where that's not the case. If the solicitor doesn't take detailed notes and then the person dies, the other kid can obviously dispute the estate under Part 4 because they think that they're entitled to more or equal share to the other child. So it's very important to have those conversations. Why? Sometimes it's about, oh, well, I've given this child a cash gift of $100,000 in their lifetime, so I want them to get less.
Yeah.
That's usually something that we can get around by having just a cash adjustment clause or gifting a cash amount being the same amount you gave to your other child during your lifetime, and then split the rest in half. If there is I guess, more sinister reason of why that child should be getting a lot less or excluded completely, you have to be careful how you go on about drafting a clause which is exclusion of beneficiary. The more evidence that we have, the better it is for the court to see that was the real intention of the testator. However, kids love fighting, so we always tell the will maker, you cannot rule from the grave. Your kid can still lodge that Part 4 claim, but I guess we'll do the best we can to justify that decision because it's human nature, Andrea, to think that your kids should be equal in everything, right? And that you've got the right to dispute that as a child, but some people have rightful reasons not to. So you shouldn't be judgmental of people's decisions to cut a child out of their will or give them less. But we should provide the advice that there is nothing, we can do what we can, but there is nothing to prevent that child eventually disputing the estate down the track.
It becomes more complicated as well as your children become not children anymore and they get married and have families, and then we've got to think about I'm the one writing the will, but my kids are now married, and what happens with the things that go on once they're married. And as you said, I can't control those sorts of things necessarily, but I can certainly put some structures in place that help with what my intentions are about that. Talk to us a bit about that, because the whole thing it can be very overwhelming. There's lots of decisions to make, and you shouldn't just make them also at one point. Like they're not set and forget sort of situations either, are they? But let's talk a little bit about the things that you can do to protect your family's assets when your children get married, and actually when their children get married, and all of that sort of stuff, because you want to make sure that you're protecting the people that you want to protect the most.
Yeah. So I think one of the most now it's very popular. Back in the day, if you have a look at old wills, they're usually what we call simple wills. I don't like calling them simple because they are a will and they're as valid and, as good as it can get being a will. However, there is an extra layer of protection that has been very popular lately, and that's incorporating testamentary trusts into your will. There's a lot to say about them. I like them. I think they're something that should always be in your will as an option, because what I say to my clients is it's always better to have something in place and not use it than look for something and not have it.
Yeah.
So the way we draft our wills here at Aintree Group Legal, we have the testamentary trust as an option. So the beneficiary doesn't need to exercise that option, but if they are in a position in their life where they feel like they need to protect their inheritance a little bit more, they can definitely use that option and establish the trust. What that trust essentially is, think about it like a living trust, but it only takes effect when the person that made the will dies. The children can then go to a lawyer and an accountant and a financial advisor and say, well, this is the terms of the will. I'm inheriting $1 million from mum's estate. I'm in a relationship. It's quite rocky. Got kids. Can we please establish the testamentary trust that has been provided as an option? When that happens, the $1 million will go into that trust. And then the primary beneficiary, the nominated beneficiary, would usually be each child. Most of the time they have separate trusts, because putting two or more adult children in the same trust is quite unreasonable when there's different opinions and perceptions of how they should be invested, the funds. And then that trust becomes the trust of one child, and then it's for their lineal descendants only as primary beneficiary, being their kids and their kids' kids, so their grandchildren. Each trust lasts 80 years, so it's actually a very long life of it, where you protect multiple generations. The husbands are usually not a part of it, or the wife, sorry. The spouse is usually excluded, and that's obviously the wishes of the testator, which means that if there's court proceedings on foot or you separate from your partner eventually, the money is protected in that trust for you and your kids only, and the court cannot really touch those funds and make an order against you for the benefit of your spouse. So I guess that's the biggest benefit. If you're a director and you're running a risky business, or there's any liquidators or creditors after you, those funds are also protected in this way. And then minors can get up to $20,000 tax-free income as well. So if you've got small children under the trust, you can you've got 3 children, that's $60,000 tax-free to each child. Whereas in a living trust, they think after $416, they're penalized with a heavy tax rate. So testamentary trust, it has that benefit compared to a normal family trust that's a living trust. So I guess it's, very important to have a think about that. And as I said, better to have them and not use them than not have them at all.
You would see all sorts of family situations, including people who come to you for probate where we haven't created the will for them. So that people can have an understanding of, we talked about simple wills, which are never simple, and estate situations are never simple, as even if they're simple, they're still not simple. What's the worst thing that you've ever seen?
The worst thing in a will, or just
in a circumstance where somebody has passed and we're now working on things? Because as you said, we don't always get the chance to sit down with someone to go through their will. So we'll sometimes be looking at a will for the first time and thinking to ourselves, what on earth was this family thinking when they decided to do this, or how are we going to fix this for everybody?
So it's always fun realizing, looking at the mistakes of older wills that you haven't drafted, other solicitors, not in this company. So what you need to do is, actually I have an example. We had clients come to us. The will wasn't drafted by us. Mum's passed away. They're here to do the will reading. And as we're reading the clause, it was about, the residuary estate clause was fine, but then there was a lot of cash gifts that didn't seem right to one of the children. And then the child thought, well, this is interesting because my mother would not have wanted that much cash going to my children. So it was about the testator's grandchildren. This is wrong. I think there has been a zero added by the drafting solicitor. It's never good when one child says that, because there's the danger of them actually stepping down as executor and disputing the estate. So you have to reason with them.
Yeah.
Unfortunately, we cannot go and talk to mum. Mum's passed away. Next best thing is looking at the solicitor's drafting notes.
Mm-hmm.
That's always hard when the law firm's closed,
Yeah.
for example, and you have to search for those paper notes from decades ago. Hopefully, we actually got in touch with the solicitor who doesn't practice anymore, and he was nice enough to come and drop the paper file for
Mm-hmm.
this very matter. Long story short, there was a note in place, very clear note from the solicitor stating that the cash was exactly as it was in the
Mm-hmm.
will, and there was even the addition of the whole amount
Yeah.
underneath each child to make it very obvious that there was no added zero there
Mm-hmm.
unintentionally, and the mum always wanted that much for the grandchildren.
Yeah.
So we had to break this to the daughter, and she wasn't very happy. However, she decided not to step down and dispute. And, at the end of the day, it is for the benefit of her own children. So
Yeah.
you
Yeah.
can't say much there. However, there could have been some kind of questioning, why not just
Yeah.
me?
Yeah.
In
Yeah.
those situations, again, you have to be very sensitive and very careful how you explain things so you do everything properly. But yeah, we needed to take those extra steps that if we were the drafting solicitors, we wouldn't have had to, I guess, go and investigate. But it happens, and we sorted it out, and all parties are happy. So it was a
Yeah.
happy ending story, but usually the child can get very aggravated and dispute. And
Yeah.
yeah.
Yeah. It's because it's such an emotionally charged sort of situation, isn't it? Like you're coming together to talk about a parent or someone else who has passed, and you're never as rational as you might be under any other circumstance. So I think that's a really good example of making sure, number one, that you actually talk to your children when you're preparing your documentation and say, look, it might look unusual, but this is actually what I'm trying to achieve. But also as the lawyers, like it's not a simple process, is it? You've got to make sure that you're taking really good notes, and thankfully the lawyer that you're talking about did have notes and could justify what had been done, that it wasn't a mistake, and the family then can understand. But that's why, and this is one of those situations where I'm going to say you get what you pay for, right?
Yeah.
Like if you go to the post office and do a $150 will off the shelf that is that sort of will, it's going to be a $150 will. It's not going to be an estate plan that is done by a lawyer that can then stand up against some scrutiny that may be forthcoming, because you don't know what's going to happen when you're passed away. It's actually none of your business because you're not there anymore. But what you want to do is make it as easy as possible for the people who are left behind to make sure that they understand what your wishes were. And you can't do that without a lawyer asking you all of those questions. It's just a unfortunate, part of life, right?
Speaking of that, we do provide our clients with what we call memo of directions or memo of wishes. And it's really good that you mentioned this, because a lot of fluff around the clauses of the wills we don't necessarily put in the will. The will is submitted for probate, and we usually keep it quite simple and tight. But all the fluff of why there was an exclusion of beneficiary clause, why one child didn't take the executor role but the other one did, why there was a cash adjustment, why one child's getting a cash gift of 100,000 and the other one isn't. That's all explained in what we call a memo of directions or memo of wishes. And I've noticed clients love this document because they can take it away with them and they can amend it throughout their lifetime. We always ask for the most updated copy, so we have it on file. We keep it together with the will in safe custody, but it's so important because, well, first of all, on emotional basis, when a person dies and the child's reading through all their wishes and what their mother or father would have wanted and why they have done certain things, a lot of closure comes through that and a lot of explanation. Another thing is when when the estate is if the estate is disputed, then that document comes as evidence of why that clause was there, and that the testator was very clear and intentional about excluding a certain person. So that document is gold for us.
Yeah.
Lawyers and clients just love talking about things and explaining things, and they've got the freedom to do it in a way where it's not prescripted. It's not checked by lawyers by being, properly written with legalese terms. The person would literally sit down with a pen or just amend it in a Word document and just express their thoughts and feelings, and they actually feel so burden free after that, they tell me. And then they can, sleep peacefully knowing one day my children will read this document and know why I have done certain things under my will.
Yeah. At what age should I get a will? This is like, how long is a piece of string, Roberta? What age should I be when I consider getting a will?
Well, you should not be under 18.
Yeah. That's probably a good start.
I say to everyone, well, it's different because you would generally want a will when you own an asset.
Okay.
So a probate application without assets wouldn't be a probate application. There's nothing to administer. Some people don't understand what assets really mean, though, because a lot of people that I talk to would say, oh, I have no assets. I only have my family home and a car.
Yeah, okay.
Those are very much assets.
Yeah.
The family home especially, you cannot sell real estate without a grant of probate.
Okay, yeah.
So it's very important that we explain to the client what assets are. Or they would say, I live with mum and dad, I only have cash in the bank and some shares. That is assets.
Yeah.
That is personal assets, and shares are very much like property. They actually have to be sold or transferred. And again, if there is no will in place, intestacy laws apply, which is legislation stating who the estate funds will be going to, or the estate assets will be going to, and it's prescribed by law.
Yeah.
So it's, spouse, partner, de facto included, children, parents, siblings, cousins and aunties, and so on. Goes in a hierarchy. So when you obviously have wishes that are inconsistent with that hierarchy,
I don't think people would know that hierarchy exists.
Exactly.
So is there somewhere I can go to actually find that out? Because I'm just thinking in my head as you're saying those things.
Yeah.
A young person who is estranged from their parents, who might have a really good relationship with their auntie or uncle or something like that, they think to themselves, oh, I've got a car and I've bought some shares or whatever. And all of a sudden they're not thinking to themselves, because nobody is at, the age of 25 or whatever. Nobody's thinking, oh, what happens if I die tomorrow? But, unfortunately things happen. What do you have to do with that? Because I'm not, that's a mind blow thing. Like, how do people work that out?
Yeah.
There's got to be somewhere online that I can say, okay, this is how the structure goes. This is what the tree looks like when I am a young person.
Yeah. So the Wills Act states a lot of things about what happens in certain situations. And if you just put in a very simple search of intestacy laws, you will come up with all the resources where you can get that list, which is obviously legislated. If you die without a will, this is what happens.
Yeah, okay.
Because there was something like, I shouldn't be quoting this, 50 to 70% of people in Australia, maybe I'll be proven wrong on this, or Victoria, die without a will.
Yeah, okay.
Which is actually a very scary statistic, because most of those people don't realize that the assets will be distributed per that list, which is not necessarily their intention.
Yeah.
And it gets really, really messy when there's blended families involved.
Yeah.
So when someone has a second spouse, they don't realize that the second spouse is actually on top. They go on top before your biological children.
Yeah. Okay.
So say the estate is $1 million prescribed by intestacy laws legislation, the spouse gets a minimum of $500,000 and whatever's left is then split between them 50% and the kids 50%. maybe that's not what the
Yeah.
person would have wanted. Maybe he or she would have wanted 1/3 each to each child and his or her spouse, but that's not what happens when you die without a will.
Yeah.
And if, say, the estate is $400,000, guess who gets everything?
Yeah.
The
Okay.
spouse.
Yeah.
The kids get nothing. So it's scary.
Yeah, it is scary.
If
It
you
really
think
is.
about it this way.
Yeah. And then, as a young person, as you said, you might have, just bought your first car, or you might be looking to buy a home, and all of a sudden, you've got those things to think about. It actually, and we do say this, I know I've heard Shane say it to people, it's actually really irresponsible to not have something in place. It is, even if you are a young person buying your first asset, or, you've got, savings in the bank, because that is something. Otherwise, because I guess what can happen if you don't have a will is that it just draws out for a really long time too. Like these things are not easy, even in the best of circumstances. So what you're trying to do is make sure that the people who you love the most are not burdened by your indecision or inability to, work on what you need to work on. And that's a really important part of it. So as soon as you have assets, is basically what you're saying, is if you've got assets and you're over 18, you need to be thinking about what your will looks like, even if it is a simple will.
Absolutely.
It's better than nothing at all.
Yep, that's right. Absolutely, because again, I've had clients that come to me and say, "Well, I have a very modest estate, very little, but I want my siblings to get it, not my parents."
Yeah.
Which is actually fair enough.
Yeah,
If your parents are well off, or you don't have connection to your parents as much, and you're very, very close with your siblings, you've grown up together. Of course, you want them to get what you have if that's your wish. That's not the list hierarchy, though.
Yeah. And then you could have things that are really important to you that you want to make sure they go to the right place. Like, just off the top of my head, I think, maybe there was a situation where you went on a holiday with an auntie or something, and you bought a piece of art or something that's, not necessarily of super value, but it's valuable to you, and you don't want it to just end up in, an op shop because somebody's just said, oh, well, this wasn't important. So it can be as simple as those things, right? Like you, in your wishes document, you can say, I would like, this tea set to go to this person, and, this piece of jewelry, for instance, you might want to go to somewhere. And, even mums who might want their jewelry to go to a particular child that they want it to go somewhere, not to the child at all, but they might want it to go to their aunt, their sister or brother, or however it might work. So there's lots of things to think about, not just, I've got no assets. Like you might not have anything that is super valuable, but it doesn't hurt to sit down with someone and just, make sure that you've got those bases covered with those sorts of things.
Of course. And also a lot of funeral wishes, you can put those in that memo document. A lot of people always say, how would my loved ones know what to do with me when I'm gone? I want this to happen. Any cremation wishes, or even the music they would like playing, the guests that they would like invited. There's just so much, I guess, sensitivity around that topic. But if it's not expressed in any documents, your loved ones would never know how to honor you after your death. So it's very important that you put that in writing and you go see a solicitor.
I want to talk about something else that is less about what happens when you die, because this particular issue is not something that is necessarily death related, which kind of, when we think about estate planning and wills, it is normally like, oh, what happens if I die? Powers of attorney. People call them power of attorneys. That's not what it is. I'm going to correct everybody who says that now. It's powers of attorney or power of attorney, not power of attorneys, which is frustrating. For me, it's frustrating. Like, that does not sound right.
Yeah.
At what point is a power of attorney important? Like, you don't even need to have a will. This is what we need to talk
Yes.
about as well. You don't have to have done a big detailed estate plan and a will to have an effective power of attorney in place. You can use them in all sorts of circumstances, right? You're going to tell us now, Roberta, what circumstances should I get a power of attorney?
So I think those documents, we call them living documents. So that's how we explain it to our clients. So your will
that's
is
a really good way of doing it.
Your will is what happens after you die. You obviously won't be around. You don't know what happens, but it's important you guide your loved ones. Your living documents being your enduring power of attorney, your appointment of medical treatment decision maker, are very important living documents because it's how you deal with your assets during your lifetime in both situations where you have decision-making capacity and you do not.
Yeah.
It's important to differentiate between that. The medical treatment, that only comes into effect if and when you lose decision-making capacity. No one is entitled to make, no one should be making, and no one is allowed to make decisions on your behalf in relation to medical decisions when you've got capacity to do so yourself. However, the enduring power of attorney, I feel like this is one of the most helpful and most popular documents because it can help people not only when they are sick or cannot make decisions, but also when they're traveling, they're not around for certain things, and their attorneys step in to make things happen and make those financial or personal decisions happen. So in an enduring power of attorney document, you can have both financial and personal decisions, or you can have them as separate documents if you have separate people making those decisions. Financial decisions include dealing with the bank, dealing with money in any type of way, helping the person sell their property if they need to do that, and also using, cash to buy things for them like medicine or if they need anything else. So just dealing with money is how I would think about it.
Yeah.
Personal decisions, those are the sensitive decisions of what happens to a person if they want to go to aged care. So helping with those personal decisions of where to go, if they can no longer walk, what kind of equipment to be purchased for that person, and how they can help the person live in the best way possible. So I guess those decisions usually made within family members, whereas sometimes my clients would want the financial decisions made by an accountant or a lawyer or someone more savvy in that regard. So yes, very, very important and handy documents. Each document can also have a lot of conditions in place to protect the person making them. So only because you are giving the attorney, making your children attorneys for, say, financial decisions, doesn't mean that they can just go to the bank and take advantage of you and withdraw all your cash and spend it on themselves. There's a lot of mechanisms in there to protect. You can make them locked as joint attorneys, so both of them have to make the decision together. If one of them does not, if one of the children does not agree, then the decision cannot be made. You can make the document starting when you lose decision-making capacity. This I usually don't recommend if you trust your attorney. Well, you should trust your attorneys, first of all, to put them in power. But it's a bit more, I guess, difficult to do that because for us to prove the document comes into effect, you have to get a letter from your GP or a medical practitioner. And if you are elderly at that stage and you just want your kids to help you, it's not very, I guess, convenient for you to be dragged to the GP's office just for the sake of being told you cannot make decisions. It's not nice. So we usually say if when you should trust your attorneys enough to give them, the decision-making power now. But if you do want to lock any mechanisms, for example, how much they can withdraw each time without a joint decision being made, you can do that. There's just so many conditions that you can put in place.
So it goes back to the point that you put these documents in place with those conditions in there, knowing that you probably will never have to use them, but if you do ever have to use them, they're there for you to use in case. I want to talk about, because this will be something that is really interesting for people who are younger who are thinking to themselves, I don't need to worry about any of this right now. Children go overseas and they go overseas for all sorts of fun reasons, and they sometimes go for 6 months or 12 months or 2 years or indefinitely if they're lucky enough to have visas that allow them to go to places for longer periods of time. But they're still wanting to come back to Australia and live here at some point. So they've still got they've got assets here, or they've got bank accounts here, or they've got passports that may need to be emergency sent to them because they have a water bottle leak in their bag. And does this sound like some situation that I've been in? It's really important for young people, I'm going to say kids because they were my kids, they still are my kids, when they're traveling to have those protections, not because something will go wrong, but because who's going to go to the bank for you and cancel your bank account and reset up a bank account for you if you haven't done that and you're, overseas and the time zone differences, and it's all a really hard thing to do. It's super easy to organise these sorts of things, isn't it? And if you're going overseas as part of your, I'm a young person, I'm going to do fun stuff, it's really important to have these protections in place and someone you trust, right? Like it doesn't have to be mum or dad. It could be if you've got an accountant or you've got a friend who you really trust and stuff like that. But somebody who is at home, who has the ability to walk into your bank or into the passport office or wherever it might be and say, I'm applying for a birth certificate for my friend because they are overseas right now and they, for some reason can't get to wherever they've got to get to.
Yeah.
So these are really simple things that young people should think about putting in place before they go overseas if they're going to do that. It's like an insurance policy.
Yeah.
You hope that you'll never have to use it. And in all of these situations, other than when you die, you hope you'll never have to use all of these things. But if you do, it's just there. And you can, send a text to your friend and say, hey, I've lost my wallet's been stolen and now I need to get hold of all of these places to cancel everything that I need to cancel. And can you do that for me because I can't do it from here, particularly if you're in places where they don't necessarily speak English and you can't, you're not able to communicate easily, time zone differences and all of that sort of stuff. It's just a really easy thing to do as a young person to give. It also then, as young person and as parent of young person, gives parent peace of mind as well that they can help you handle those things when you're away. So there's some really easy things that you can do as a young person to, give your parents peace of mind when they're, going through the process too, which is important. How many young people do you see, Roberta? I imagine that the average age of somebody who's thinking about estate planning is a little higher than the person that's going overseas to have some fun as a 20-year-old.
Yes, that's right. I don't see a lot of young people, unfortunately, and then we are faced with horror stories of young couples going through very unexpected deaths, etc.
Yeah.
I had a case where I was actually it's quite sad. We were in the process of preparing a will for a client, and he was a sole director of a company and had multiple trusts and a very young family, had a wife and an infant and a 2-year-old. Unexpectedly died in Bali, heart attack. No one ever thought anything was wrong with this person. It's so hard when you die overseas as well because you wouldn't just get a death certificate. You would get a coroner's report.
Yeah.
You would get a police certificate in another language. You need to translate that. So his will wasn't signed because they never thought they needed to push it.
Yeah.
They were young. Well, she's still around. They were in their 30s.
Yeah.
So they weren't pushing each other to sign the wills or anything like that. And they thought this is not going to, we won't need this document until we are, 80, 90. And what happened, unfortunately, is because he was a sole director, the business was in the process of being sold. So we actually had to apply for urgent letters of administration and put the wife in charge
Yeah.
because employees weren't getting paid, the payroll was paused, the business was in the process of settling who was going to sign off.
Yeah.
The director has passed away. The purchaser started pushing back on actually finalizing the sale because they were getting freaked
Yeah.
out by
Yeah.
the whole thing. And this would have been very much quicker, just a lot quicker if she was appointed as executor and there was a signed will in place.
Yeah.
So lesson learned from this is there was obviously a lot more costs incurred, but it was actually very hard for her as well.
Yeah. Yeah.
The last thing she wanted was to do an affidavit to explain why she was next of kin,
Yeah.
how she was connected to him, how many years they were together, because she was de facto. She wasn't his legal spouse, his wife. So it was just so hard grieving and at the same time getting evidence for an urgent application of why you should be considered his partner
Yeah.
and supplying photos and talking about the children you just had is horrible.
Yeah.
She was going through it. And this could have all been avoided if they had estate planning done in place earlier. So my answer to your question is you should not be waiting until you are what you consider old because unfortunately life happens and anything can happen to you or your loved one at any given time. So you are really just you don't know. Life is just really stressful and it can happen anytime.
Exactly. And I think that's the point is that, it's really important to have people in your life who you can trust with all of these matters. It's an investment. If you see it as an investment in your future rather than an expense of what you've got to fork out, because most people are like, oh, you've got to pay for this sort of stuff. But in the long run, it will actually save a lot of in that particular circumstance, a huge amount of stress for the spouse that's left behind, who's having to go through all of the process, as well as grieve for a family situation that has been really tragic. There's no amount of money that can make any of that any better. I'm sure that if they had their time over, they would make different decisions and do things in a much faster fashion. So I think the final point that we can make, and there's as we said, this is a number of series of what your lawyer needs to know. I think, Roberta, that is a really poignant story to finish on, is that what your lawyer in this situation wants you to know is that you need to act on these things and you need to act on them way before you think you're old, because that's really important. There is no inappropriate age to start talking about what your legacy will look like and what your estate plan looks like. And so thank you so much for coming into the podcast studio today, Roberta. We look forward to the rest of the series of what your lawyer wants you to know. Anybody who wants to be in touch with our Aintree Group legal team, all of the details will be shared as part of the podcast episode, as we always do. And we will also include a link for people to find out what the rules are with regard to who gets what in the basis that you pass away without a will. So hopefully people can look at that and think to themselves, that is not what I want to have happen. So they will reach out to you. There are lots of places that you can go to get wills. And if you are in a situation where you can't afford to have a will written, but you do need to get one, there are government-related bodies that help people with wills, right, Roberta? There's also lots of people that are associated with aged care facilities and things that make sure people are looked after when they need it most. So, but otherwise, feel free to give our Aintree Group legal team a call. They are amazing at what they do, having all of my estate planning done by our wonderful lawyers here as well. So thank you for coming in, and we'll hear from you again soon.
Thank you, Andrea. It was my pleasure being on. Thanks, guys.